Brian Kohberger's case won't go to trial, if it does, until 2026. Why? Well, let's talk about some of the reasons that we know of right now, even though there's a gag order, which means the attorneys can't talk to the public or to the press. We know through their filings what they've been up to in this case. And when I say filings, what they've filed with the clerk's office in Watauga County in Moscow, everything is uploaded and actually put out there for the public to see unless it's sealed. But we can see what the attorneys have been doing and what they haven't been doing and why it's going to take this case that long to get to trial. Let's start off, number one, with the fact that you haven't even had the judge determine whether or not cameras are going to be allowed in the courtroom for preliminary matters. That's a big deal because you're going to have, let's say the judge says no cameras in the courtroom. Then you have the big media companies who are going to appeal the judge. And that could hold up the case until it'll come back quickly on whether or not an appellate court thinks the judge made the right or wrong decision. Although a judge's call on whether cameras should be allowed in the courtroom, appellate courts usually go by what that judge has ruled. Because that judge is in the best position to know. That's just the cameras part of it. Now, let's get into some of the motions, the major motions that the defense hasn't even started on yet, okay? First one is motion to change venue. That's coming. What does that mean? Well, that means the defense has to file this. They have to file a motion to change venue, meaning they're saying that the jury pool in Moscow right there is not going to be fair. That they've been hearing about this case every day, every minute of every day since the homicides occurred. That the judge should move the case to another county in Idaho. You can't move it to another state. It has to be moved within the state of Idaho. And you're saying, is that really going to make a big difference? Well, maybe. And the prosecutors know that this is something, too, that they may have to let go. This case probably changes venue, folks, because a judge and the prosecutor can't make a mistake on this by trying the whole case right there, basically on the campus, and have an appellate court later come back and say, we're going to have to try this case again because you should have taken this case to another county in Idaho and tried it in front of a different jury pool. That's coming. It's going to be a big motion. That hasn't even been filed yet. Then, okay, motions to suppress physical evidence. These are the most important motions that you can make as a defense attorney when you're dealing with overwhelming physical evidence and scientific evidence in a murder case. Excuse me. So you have a primary scene where the homicides took place, the house, right? That's a primary crime scene. But then you have warrants that were served and executed on Kohberger's apartment in the Washington State campus, at his parents' home in Pennsylvania, in his car, which I think is the biggest piece of evidence against him right now. His phone. These were warrants that were executed, giving law enforcement the ability to search these places and to seize items that they believe are evidence of a crime. Therefore, these, his home, his apartment, they're crime scenes. You're thinking, if there's evidence of a crime from these places, then it is a scene under the law procedurally from when you're challenging the evidence under the Fourth Amendment, illegal search and seizure. The defense has an uphill battle here. There's several things they have to do. First of all, they have to hire experts to explain to them the type of evidence that's been seized or found in, let's say, Kohberger's car, or it's scientific evidence. These are lawyers. They're not doctors. They're not scientists. We need to hire individuals to explain to us, what is that? Can it be contaminated? What does it show? Did the state's lab people or experts, did they get anything wrong here? That all has to be evaluated from the lab reports and the discovery that's been coming in these past several months. Then once the defense challenges the evidence that's seized, let's say they want evidence from his phone to be suppressed because it was obtained illegally. Once you write that written motion citing the Fourth Amendment and constitutional issues as to why it should be suppressed, it triggers a hearing in court, like a mini trial where the state then has to bring in their experts. They have to explain what it is that they did to get the warrant. They have to explain how they seized items, all these things are brought up, and these could take weeks just in the courtroom to litigate. So you're talking about motions to suppress all kinds of different, the DNA, for instance, there's going to be motions to suppress the DNA, right? It's the main evidence that's coming out against it. The defense hasn't even started on yet. I don't think they've even hired the expert that they're going to use on DNA yet. That costs money and that has to be appropriated. There's so many things going on, many moving parts in this case. You got 4 victims, folks. Okay, so You've got venue. You've got motions to challenge the evidence that's been seized in this case that the state is going to be used as guilt of Kohberger's crimes, right? The defense hasn't even started on that. It's almost October of 2023. So motions to suppress physical evidence, depositions. The court's going to allow attorneys to take depositions, which are opportunities for the defense to sit down and question witnesses for the state. Same thing if the defense provides witnesses, then the prosecutors may have to take an opportunity to depose or question witnesses. This takes time as well. Did Kohberger give any statements in Pennsylvania? We don't know about it. It was a gag order. Did he give any statements that the defense has to suppress, meaning that statement was taken illegally, or he shouldn't have said that, or you made him say something on the plane from Pennsylvania to Idaho? We don't know. We don't know if he's been talking to lawyers or law enforcement with his lawyers. We don't know. So there's a lot. As a defense attorney, you've got to go through and move to suppress all the evidence that you can. It's your job, because if you don't, an appellate court's going to say, "Hey, lawyer Mark, you didn't challenge this evidence. You're going to have to give this guy a new trial." That's what the stakes are here, folks. So, I'm hard on the defense. I think the evidence is overwhelming against Kohberger, but I know what their job is and I know what they have to do. And there's a mental aspect of this too, a mental health aspect. You're an attorney and you're working with a guy like Kohberger every day. You think Ann Taylor likes this guy? You think the defense team, they like him? They have to put that out of their heads completely. Their job when they get it, I've done cases like this. I used to have to tell myself driving into work in the morning, you're doing this for the Constitution. You're doing this for the right for people to have fair trials in the future. You're doing this not for this particular individual in this case. You're doing it for the Constitution, the system. This will be one case in a career for Ann Taylor, but it'll be her biggest case. She doesn't like this guy. She has to maintain her sanity. Do you know how hard it is to do this job every single day? The darkness that you see with these pictures. You're seeing pictures of the crime scene. You're seeing the autopsy. You're seeing the photos of the children killed. A judge has to look and make sure that the attorneys in his or her courtroom are, not getting burnt out. The prosecutors and the defense attorneys looking at each other have to determine, hey, there's some burnout going on here. You have to be able to have a life as a lawyer doing a case like this. You want to coach, you want to take your kids to dance, you want to be a good husband, wife, person, friend. I'm going to tell you something. It's very hard, it's very isolating, and it's a mind fuck. I don't do these anymore. They took a piece of my soul when I did cases like this. There were clients that I absolutely despised and wanted to in my head, I'll admit this to you now, there were times that I wanted to do violent things to individuals accused of crimes that are just so disgusting. I don't want to discuss them here with you. So there's a toll that takes place on the lawyers handling this on a day-to-day basis, and they need some time. In the next couple of years, they're going to need a few weeks here and there, folks. Because again, as a public, as Americans, we want Kohberger to get the fairest trial possible. That way, if you want execution, then you can justify it because the trial was fair and the sentence, as you see it, will be fair. Nobody wants a kangaroo trial like in these other countries. Now, if you want justice done and you want punishment done, then you have to hope that this trial is so fair that there's not going to be any question on appeal that this ever comes back and puts those families through this again. So Ann Taylor and her team are very important. The prosecutors and their team is so important. We need them to hang in there with their mental health. The clerks, the judge, they have to move to another county to try this case. Can you imagine the toll that this takes on their families? And them personally? Kohberger is sucking the energy out of Idaho financially, mentally. It's a big deal, and there's a lot coming, folks. And honestly, 2026 is a little bit conservative. Jury selection in this case alone is going to take months to find 12 people. If I have 12 people who can be fair anywhere in Idaho, we have to find them. You have to find them. The attorneys do, to make sure that a fair trial is granted in this case. Stay tuned. I've got more for you.